Property management agreements. Just as written agency or representation requirements are required when representing a buyer or seller, a written representation agreement must exist when representing property owners or tenants in a property management situation. Signing for clients. Sometimes a licensee may be asked to sign a document on behalf of a client. For example, a client may be out of town or unable to sign a purchase contract. Licensees may sign on behalf of their clients, but certain restrictions apply. Licensees may only sign on behalf of a client under a document called a power of attorney. A power of attorney appoints an attorney-in-fact for a person. The attorney-in-fact has the legal authority to sign documents on behalf of an individual executing the power of attorney. When signing under the authority of a power of attorney, the attorney-in-fact must use a specific format with the signature. Let's review an example. Our licensee will be Larry Licensee. Our client will be Bob Buyer. Bob has executed a power of attorney authorizing Larry to be Bob's attorney-in-fact. When Larry Licensee signs for Bob Buyer, Larry must sign as follows: Bob Buyer by Larry Licensee, attorney-in-fact. If Larry must initial a contract for Bob, Larry must initial as follows: BB by LL, attorney-in-fact for Bob Buyer. Approved forms. In another course, we review the forms which have been approved by the Division of Real Estate for licensees to fill out. Licensees are not allowed to alter, cross out, white out, or otherwise make any changes to any state-approved forms. We cover this in great detail in the course on state-approved forms. Licensees may also fill out or complete forms prepared by a licensed attorney. The attorney does not need to be employed by the buyer, seller, lessee, or lessor. For example, there is no state-approved form for a lease agreement. A licensee may purchase a form from a company to use, since the form will be prepared by an attorney. Real estate auctions. A real estate license entitles a licensee to participate in real estate auctions. A principal broker may want to affiliate with an auction company to facilitate or manage the auction of real property. If a principal broker enters into such an arrangement, certain restrictions apply. Advertising. All advertising must conspicuously disclose the identity of the principal broker with whom the auction company is associating and who is supervising the auction. Supervision. The auction must be conducted under the supervision of the principal broker. The principal broker must be physically present at the actual auction. Use of approved forms. When the auction is complete and a winner is determined, the state-approved forms must be used as the purchase contract on the transaction. If the state-approved form is not used, a form prepared by an attorney must be used. Placement of deposits. When the auction is complete and a purchase contract has been signed, any earnest money deposits must be deposited in the principal broker's trust account or other depository as agreed to by both parties in writing. Closing arrangements. As with any closing in which a principal broker is involved, the principal broker is responsible for overseeing the closing and ensuring that all closing documents are accurate and complete. Guaranteed sales plans. A guaranteed sales plan is basically an agreement with the seller and some other party, wherein the seller is guaranteed a certain sales price if the home does not sell within a certain period of time. Some brokerages use such plans as a marketing tool to obtain listings. Often employers will contract with relocation companies to handle the relocation of company employees. Many times, the relocation company will purchase the home from the employee if the home does not sell. This is a form of a guaranteed sales program. If a guaranteed sales program is used, full disclosure of certain terms of the agreement must be made in writing to the seller. Written advertising. Any advertisement of a guaranteed sales plan must advise potential sellers of certain terms, restrictions, and costs that may apply. The advertisement must also recommend for potential clients to inquire as to the details. This disclosure must be printed in a font at least 1/4 as large as the largest print in the advertisement. Radio, television advertising. Any radio or television advertising must also contain a conspicuous statement informing listeners or viewers that terms and conditions may apply. The agreement. The actual guaranteed sales agreement must be in writing and include the following provisions and information: all conditions and terms under which the property is guaranteed to be sold or purchased, all charges for the service or plan, price for which the property will be sold, the approximate net proceeds the seller may expect to realize, disclosure of fees. A licensee may have the opportunity to receive fees other than the real estate commission. We have discussed the fact that real estate licensees are prohibited from receiving referral fees from lenders. However, licensees may receive referrals from other parties. Referral fees from allowed sources must be disclosed in writing to all parties of the transaction. The parties do not necessarily need to consent to the fees being paid to the licensee, but the fee must be disclosed.